the introduction. Uh,
Good morning or good afternoon, everyone.
so I'm Sigrid Haynes,
I'm Emily Lashley.
and we have slightly different practice areas, but we work together closely, and so we thought it would be helpful to have both of our backgrounds. This is Sigrid Haynes again. I do healthcare law, and I began to file a lot of guardianships against our hospital patients and nursing home patients. So it began to be an area of focus for me, and we thought it would be helpful to have some background. Emily's a litigator.
I am. I do corporate practice, I do guardianships, estates and trusts, and I do litigation in a variety of those areas and other areas as well. So I kind of approach things from a different perspective sometimes, with the potential of litigation always kind of in the back of my mind. So it just gives me a different outlook on things.
So I like to think of myself as an upfront problem solver, and then when I can, I run down the hall and find Emily. So it's great. So we've captioned it as guardianship, and I think we probably should have captioned it as guardianship and powers of attorney. You really cannot talk about one without the other. They are closely related concepts, and I think that it's important to understand both of them so that you can understand which tool will best solve your problem. So the first thing we want to think about, and I'd never thought about my life this way until I started doing a lot of this kind of work, is that everyone's life has two parts, the personal side of their life and the financial side of their life. So the personal side of your life decides where you live, who your friends are going to be, what food you want to eat, what decisions that you make about your health care needs. So, for example, if you're willing to have surgery or you want to have a particular course of treatment, that's on the personal side. And then the financial side is all the things that are related to your finances. So the control of your money, your house, your property, your bank accounts, all of those kinds of things. And pretty much all decisions that you make in your life fall into one or the other. Although, of course, there are some overlap areas like where you live. You need to be able to afford where you live. You need to be able to pay for it. But you can also choose, if you've got X many dollars per month, you can choose to live here or there or whatever. So we try to get harmony in those two sides of things. And it's important to understand the concept of the fact that all decisions fall into one of these two camps, with admittedly some overlap, because it will help explain the concept of the powers of attorney and the two types of guardianship that are available, and the fact that they often have independent and can be treated independently, but should be kept in harmony whenever possible. So a competent adult, and an adult under Maryland law, and I think in most every state, if not all, a competent adult is a person who has attained his or her 18th birthday. And a competent adult has autonomy to make decisions. There are very few limitations on that, to make decisions for themselves. And we all kind of know what the limitations are, but by and large, you get to make your own decisions about where you live, how you want to spend your money, those kinds of things. And then you can delegate your decision-making authority to someone else. Here we get down to the two concepts. You can use a power of attorney for finance, or you can use what we used to call a healthcare power of attorney, or a power of attorney for healthcare decision-making. In Maryland, we now call it an advance directive appointing an agent being the person that you make decisions for, that you decide. So I might want to have my husband make my decisions, or my child. I have neither, so I can insult both with impunity in the course of the next hour, and you will probably hear me do so. So I think it's helpful to understand the power of attorney for finance and the power of attorney for healthcare are two different concepts, and we're going to see more of that as we go forward. So a power of attorney is a very powerful document. It is the complete delegation by the competent adult to someone else to make decisions for themselves. The powers can be broad, they can be limited, they can have specific instructions and limitations. The concept that you might hear about, for example, at a power of attorney for finance is the person is going abroad, they're on a business trip or they're in the military, and they need to delegate their decision-making authority to their wife to handle the closing or the purchase of their house. And so they might give their wife a very limited power of attorney just to handle the purchase of the house that is a blah 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 address and is going to close in 10 days, and I give my wife the authority to sign all those papers on my behalf. Or maybe I give my husband all decision-making authority, and so I can say you can do anything that you see fit under the scope of this document. So that can be obviously very broad, and I'll tell you a little story later about why these forms can be used and misused, and because they are so powerful. So the document is to be tailored to the specific needs that the person has. They can be limited. You could say, oh, you can only make certain decisions in certain contexts. The document must be produced by the principal. I find the principal is the person who made it, and so the principal is responsible for producing it. The agent, by default, often ends up being the one who produces it. But the document is something that the principal needs to produce if they want to use it, and it is often lost. And so, we're kind of cautious. When I get the situation with hospital or nursing home patients, somebody will come in and say, oh, I'm so-and-so's power of attorney. And we always say, where's the document? Because you need to be able to produce it, and they often can't find it. It's sometimes locked in a safe deposit box. People forget that by definition they may not be able to get at it when they need it if it's locked in a safe deposit box. But it's important to know where the documents are. A power of attorney can be easily revised or revoked. Similar execution requirements would be necessary to revise it. It can be revoked in pretty much any old form that you can think of. Tear it up, write a new document that says I revoke it, and typically a newer document displaces the older document by definition. So if I sign a power of attorney in 2018, and then I do a new one in 2019, it typically revokes the prior one. The document can become out of date, not by operation of law. They typically do not have expiration dates, although you could put one in there, but typically they don't expire just because they're old. Typically they become unusable because, for example, the agents are not available. I find, particularly with elderly clients, they'll name their husband and their next door neighbor and their best friend as their agents, and their husband's passed away, the next door neighbor's incapacitated, the other next door neighbor moved to Florida and we can't find her. So it's important to review these documents periodically and to ask people to review them periodically to make sure that they're current. The agent is not compelled to act. So I could name Emily as my agent, and Emily decides to run away, or she started dealing with me, or I stabbed her with a pen or something, and she decides that she does not want to act as my agent. She's not compelled to do so. This is a voluntary delegation of authority to someone else, and the agent can decide that they don't want to do something. They might fail to do some particular thing. For example, just because I gave Emily the power to handle my finances does not mean that she's going to get around to remembering to file my taxes. She's not required to do that. She can do it if I ask her to do that, but maybe she doesn't. So there's no authority, or there's no responsibility or compulsion that's put on an agent, unlike a guardianship, and we'll talk about that in a few minutes. There are forms that can be used. For the advance directive appointing an agent under Maryland law, we have a specific statutory form, but it is only suggested. There are a variety of forms that are used, and so people may tailor it. They may use their own form. They may move here from Rhode Island and bring the form they had in Rhode Island. So they don't necessarily need to use the statutory form for the healthcare decision-making authority, although we generally encourage it. It's a pretty good form. There is a statutory form for the financial power of attorney form, and those can be must be strictly followed, and the witnesses must be strictly adhered to. But then sometimes people do an additional one, and Emily, as an estate planner, may want to address why you might use a statutory form and an individual form.
So a statutory form is often required when you're dealing with financial institutions or investment banking, investment accounts. Some of those places are very particular about the forms that they will accept on behalf of a principal or from an agent acting on behalf of a principal. So they either want their own form used, which if you're dealing with someone who does not necessarily have the capacity to grant a new power of attorney or to sign a new power of attorney, then all you have to rely on is your old form. And if it is not that statutory form in compliance with Maryland law, they may not accept it. They may require only the use of their own form, which is the catch-22. You can't get it anymore. That's one of the limitations that we have in here. And the statutory form is more often than not accepted by these institutions because it is in compliance, and their forms will be in compliance as well. However, I have come across rare occasions when they won't even take this Maryland statutory form when it comes to financial powers of attorney. So you want to make it as detailed and as particular as possible rather than just doing a general power of attorney. You want to make sure that they can be long. You want to make sure that it includes almost everything you can possibly think of as far as investments go, as far as accessing accounts, accessing past records, giving somebody the opportunity. And it's kind of scary because you are then turning over the power to someone else to do anything and everything having to do with your finances. But it is important, if you are going to need it in the future, to make sure that it is very detailed, because you could run across a situation if it's not specifically identified in either that statutory form or some other form, or that you've changed along the way. If it's not specifically identified in there, a particular financial institution or investment company may not accept it and may not let you do what you need to do. You might not specifically have the power to sell stocks. You might have the power only to have access to the information. So if it isn't spelled out within the document, you won't be able to do anything.
I had a case where I was trying to sell a car for one of my clients using a power of attorney, and CarMax, the poor guy at CarMax, who's the front-end person that I'm dealing with, says, well, there's no provision here that allows you to sell my car. And I was reliant on the provision that any lawyer would say that I can handle his property. But, it would have been helpful in that particular case had we thought of it to say, including selling my car, so that I can explain it to the CarMax salesman and didn't have to rattle his manager and their CarMax legal counsel to convince them that I had this right. One thing I'll mention about the statutory form is that one of the reasons that I like it, and this is where I'm showing my age, Emily's a little younger than I am, the Maryland law that passed the statutory form was passed and adopted on October 1st, 2014, I believe. And that form, before that, we had every different bank demanding its own form be used. And as Emily referenced, they still sometimes give you a hard time. You might get one of the banks saying, oh, we don't know what this form is or whatever. And one of the things that I loved about the new law is that it allows for the recovery of legal fees against financial institutions that do not recognize the use of the statutory form. And I have on occasion written letters on attorney letterhead to say, oh, I look forward to you paying my legal fees while I get you to do the right thing under Maryland law. And that usually will cause them to recognize the statutory form. I remember one time a bank calling and pleading, please, please, please don't bring an enforcement action. We will do it. So the statutory form in that regard has been great. But one of the tricks that we put in the second to last bullet point is that sometimes the agent can misuse the document or not act in accordance with the principal's instructions. Against the principal is the person who made it. It's a very powerful document, and so when the delegation is given, it should be used in a fashion that is consistent with the principal's instructions. So we have a statutory process for healthcare decision-making. Many of you are probably familiar with the fact that under Maryland law, there is a list of persons who can make decisions as a healthcare surrogate for those who have been deemed to be incapacitated. So typically, we have a person who can't make their own decisions, and there's a statutory process to be followed for healthcare decision-making if we can find a family member in a statutory order, or even a friend who's willing to sign an affidavit that they know this person what they would want. They can make healthcare decisions for them. We have no counterpart for financial decision-making authority, which brings us to the guardianship discussion. And one of my other points about the power of attorney form, and I maybe should have mentioned this in the outline, but it is such a powerful document to delegate authority to someone else. In a healthcare context, it's a little bit harder to misuse it, because if the person is competent or able to make their wishes known, they can revoke it. I could give Emily my decision-making authority, and she could say, okay, let's amputate her head. And the doctors come in to wheel me off to the operating room, and I sit up and I say, absolutely not. I'm not going along with that. I revoke the power of attorney that I gave to Emily, or I do not agree with this authority. I'm using a slightly ridiculous example, but it becomes a more problematic situation when you've got the situation of a patient who has given a decision-making authority to someone under a power of attorney, or even if we're using surrogate decision-making, and the patient simply does not want to go along with the plan. I've given my evil husband decision-making authority. and he has consented to something or other, and I say, maybe I really need it. Maybe if I was not sick, I would be consenting to it, but now I'm sick and I'm scared and I'm upset. I don't understand what's going on. And I say, no, no, no. It makes me uncomfortable from a risk management perspective to then force medical treatment on a person who is not agreeing with that. So I think that's always a caution that makes me worry about something like that. And I think it's also worth mentioning, and in the healthcare context, of course, that's a little bit easier. In the financial context, there's the obvious capacity for the financial power of attorney to run off with all of one's money, or to fraudulently transfer the house, or to steal assets or whatever. Powers of attorney are extremely powerful documents, and I don't think people always think about that as much as they should when they do sign them. They think about the worst case scenario, but they should make sure that the agent acting under the power of attorney is trustworthy. And my favorite war story, if you've heard me talk, I always find a way to work this into almost every talk, but my favorite war story about the power of attorney document is I was hospital counsel some years ago to an area hospital. And of course, on Christmas Eve, we got a man coming in, and he's got a brain tumor that has caused a good bit of swelling in his brain, and he's unable to make his decisions. And he has a girlfriend who shows up with a power of attorney document, and it looks to be validly executed. The witness requirements have been met. It names her, was signed within the last year or two. It looks like it's, maybe it was even older, I don't remember, and it wouldn't matter. But it seems to be facially valid, and the witnesses, look like they'd signed at the same time. And it says, I name, Susie Girlfriend to be my healthcare agent. And lo and behold, sitting on the other side of the bed is this man's wife of 30 years. And the wife gets an attorney who calls me and starts yelling at me and calling me all kinds of bad names about the fact that the wife should be the decision maker for this incapacitated guy. And I said, well, under the Maryland statutory authority, under the pecking order, the girlfriend has got the decision-making authority over the wife of 30 years. And as you might guess, the lawyer called me a bunch of bad names, and he said, oh, they broke up, and, he just gave her this document, and they're not going out anymore, and blah, 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 about all the reasons why she was a bad person, and called her some names that rhyme with witch. And I said, I hear you, and you can go to court and tell all this to a judge, but the power of attorney form is supersedes the wife of 30 years, and she's the decision-making person for now. And he was not very happy with me, and it being Christmas Eve, he was stuck with a 3-day weekend, before he could get to court. So I called the hospital on Monday morning after Christmas to find out whether we were going to be going to court. And our position on that as hospital counsel or counsel to the healthcare provider is we just do what the court tells us. We, with the law's clear, we follow the law. And then if the person wants to challenge it, maybe you can convince the judge to invalidate the power of attorney because they broke up or whatever. And so I called the hospital on Monday morning to find out, if I was going to be going to court, just to listen and find out what the judge would decide. And the postscript on that one was that they gave the patient a bunch of steroids, brain swelling came down, and he left the hospital with the wife on one arm and the girlfriend on the other. I don't know what happened after that. But it's a very powerful document, and I use that partly because it's amusing, but mostly because it really illustrates how strong these documents are. They're very powerful.
Mm-hmm. Just to kind of piggyback on what Sigrid has said, another aspect of the power of attorney is the fact that nobody is there to really regulate them. You can sign them. I could sign one right now, giving all of my decision-making power to Sigrid, and nobody could stop me. I could do it as long as I have the capacity to do it.
And I'm going to run off with your house, your car, woohoo!
Exactly, and make sure you take my kids as well. They have to come with
me.
Oh,
no, because I can do what I want under a power of attorney. I'm not taking your kids.
Oh, so close. But unlike guardianships, which we'll get into, there is no court intervention when you're assigning someone as your attorney, in fact. When you're signing that power of attorney and you're not relinquishing the rights, but you're giving someone else to act either with you or on your behalf, there's no checks and balances system unless, given Sigrid's example, the person who believes they should have the authority, like the wife, for example, would have to go to court and have the court invalidate the other power of attorney for one reason or another.
And can they demand an accounting at that point?
They can demand an accounting, absolutely, but it would have to be part of a litigation action in order to make sure, in order to get that authority as the girlfriend, for example, would not have to simply relinquish that information to the wife. She has no authority to request it other than in the form of a litigation matter,
To go to court.
is expensive and time consuming and you might not have results immediately.
Mm-hmm. And obviously ups the stakes in terms of bad will and contentiousness.
Correct.
So we have, of course, only I think 15% of the population has done a healthcare power of attorney. Perhaps the same number, or perhaps even less or more, have done a financial power of attorney. Or so the 85% or whatever people don't have any powers of attorneys on, or maybe they have a power of attorney and it's not valid anymore. It was not properly witnessed. It was not, the agents are not able or willing to act for all the variety of reasons. So then what do? Well, then we end up going to court, because that's really our only remaining alternative, particularly if we need to be able to get money from a person who's incapacitated and they need to pay their bills, they need to sell their house, they need to file their taxes. So we file a guardianship, and that puts the person under court jurisdiction. Under the law, it is always to be the last resort, and it is anyway, because it's expensive and it imposes a lot of restrictions on the person's life. It really kind of ups the ante. But as we saw before, we can file a power of attorney for finance or a power of attorney for healthcare, or both. And we'll talk a little bit about some decision-making scenarios as to when to file one versus the other. But the point is, again, there's two sides to everybody's life, and you can file a power of attorney for healthcare. File a guardianship for healthcare or personal decision-making authority, a guardianship for person, guardianship for both. In order to file a guardianship, we need to have 2 certificates of incapacity. So that's a threshold for filing for guardianship. There is a special provision to force the person into a medical evaluation if they're being held hostage by their family member, but that's a rare situation. Typically, it's the scenario where we really do need this in order to file. So 2 physicians, or 1 physician and 1 psychologist or licensed clinical social worker, must certify on specific court-issued forms that are completely filled out that the alleged disabled person lacks capacity. And these forms are set forth in statute under Maryland law, and they're Googleable on the web and on the court website.
They are. We have included the links here, but don't click the links on your screen right now. It'll mess everything up. We might not know how to get back to you. But yes, they are available either through the Maryland Judiciary website and search court forms, or you can certainly Google Maryland Physician Certificate, Maryland Psychologist Certificate, or Maryland LCSWC Certificate, and they'll be there in PDF forms.
And you mentioned in here when we were working on this, completely filled out.
They do. Oftentimes you'll have a physician complete a form, and one of the sections within this form is to list the medications that the person may be taking. Well, oftentimes the physician just writes "see attached" because they know the person's taking a bunch of medication. They might not remember it offhand, or it's 75 things and there's not enough room on the form to include all of them. So they write "see attached." Well, if we as attorneys are preparing the petition and we have these certificates, we see that they're signed. We see that they're signed within the proper time frame, because they cannot be aged certificates. They have to be within 21 of them, at least has to be within 21 days of when we file. That way you're not dealing with somebody who was maybe having a rough day, physician saw him 2 years ago, and now someone's trying to become a guardian and they really might not need one. But the point is that the physician will fill out the certificate, write "see attached," but not attach anything. And so we have now, as the attorneys preparing the document, have come to review these certificates much more thoroughly than we may have in the past. We always look at it to see what the diagnosis might be. Did they check the correct boxes for, yes, the person needs a guardian? We certainly don't want to file a petition where the physician has said, no, they don't need a guardian. And especially if, we were originally only filing for maybe guardian of property, but the physician has said there's nobody to make the person's decisions from a healthcare perspective, and they also need a guardian of person. So we do want to make sure that, A, we're reviewing the forms for the accuracy, but to make sure that they're also complete. If there is a box that needs to be checked, even if it's writing "not applicable," we have to include that, otherwise the courts nowadays will reject them.
Yes, the court clerks are extremely picky, and it's a 5-page form with a whole lot of little boxes, and doctors went to medical school not to fill out paperwork, so There's a significant percentage of time as lawyers where we go back and we're like, could you get the doctor to fill out the little box on page 2? So it is important that the certificates be completed and at least one be done within 21 days.
Correct.
Based on personal examination also.
Correct.
The other thing we find is that sometimes doctors will, as a favor, fill one out for the other doctor and they didn't personally examine the patient. And these certificates can make them witnesses in litigation. So they need to be able to say that they based it, because they're certifying to that, on a personal examination of the patient.
Exactly. And one good thing about the new age forms and the new age online filing of these guardianship proceedings is we don't need originals anymore. We used to need the original physician certificates. Now we can just simply have them scanned over to us, email, fax even. We've even had some people take pictures and send them one page at a time of each, each.
As painful as that is.
Yeah, it's not ideal, but it gives us options as far as obtaining the certificates. It gives us a little more wiggle room on filing, especially if we need to file something on an emergency basis.
And I think another important thing to understand when we file a guardianship, we have to give notice to immediate family members. And this sometimes causes some angst because sometimes people are trying to help their mom, grandma, whatever, and they don't want to tell the black sheep brother because they're afraid that's going to make trouble. We have to notify all the immediate family members, the interested persons, because they are entitled to notice of the guardianship so that they can come into court to object. And when we file this and we get information from our institutional clients, we sometimes find that they're not very good about giving us full information, often because they haven't gotten it from the family. It's not that the institutional clients are lazy, but they might just get the most assertive son or daughter, and there's a daughter living in Belgium and doesn't respond to fairly things. We still have to notify that person of the guardianship and serve them with certain papers. So when we file it, there are certain specific facts we have to put forth in the document. You'll sometimes find that we ask some funny questions. If it's filed for an individual, we have to ask how old they are. If they're the individual petitioner, it's a funny court rule, but there it is. So we do sometimes have to ask some funny questions. So the person who files the guardianship is called the petitioner because they're petitioning the court for relief. And when they file the petition with the local county circuit court, typically of the jurisdiction of the person's residence.
Correct.
There are whole books that Emily could write about jurisdictional issues, but we typically file it in the county of their residence. We have to allege certain specified facts in the guardianship petition, and we have to be seeking to place the alleged disabled party under guardianship.
One of the newer requirements is we have to specifically allege whether or not the alleged disabled person is a recipient of any benefits from the Veterans Administration. So if that's a fairly new requirement for these petitions, and we used to just be able to say, we think they're receiving benefits from Social Security, or we're not aware of any other benefits that they may be receiving if we don't have the information. A lot of times when we're dealing with a healthcare facility or a hospital, if the person comes in through the ER and there's not a family member who can provide any information and that person can't really convey the information, we're at a loss and simply saying to the court, we don't know. Well, we have to specifically include a separate sentence that identifies whether or not the person is not, or we don't know whether or not they're a recipient of VA benefits. Just one of those real nitpicky things that the court is after these days. So if you happen to ask that question, stick it in the back of your mind.
Good one. So the petitioner, that's the person who files again, can be anyone with an interest in the alleged disabled party's well-being. They have to have what's called standing, so they have to have some interest in it. And typically that could be a hospital, CCRC nursing home that has the person as a resident or as a patient. So maybe they're trying to get their bills paid, or maybe they're trying to get the person placed, or maybe they're trying to get healthcare decisions made. So many of the petitioners that we represent are institutional clients, but they can also be a friend or a family member, even a financial institution that is worried about one of their depositors or one of their clients. So, but the petitioner does incur the legal fees of pursuing the guardianship, so which can become significant in some cases, and we can talk about how likely it is to be contested or whatever, which can obviously drive up the cost. The petitioner also has the burden of proof. So they have the burden of pursuing it. Like any litigation, once you file it, you have an obligation to establish your case. And again, we can seek a guardian of person, a guardian of property, or both. And the petitioner should be careful to analyze its goals. And I think this is one of the things that we try really hard with our clients to try to focus on. Does the alleged disabled party, the person that we're filing, the defendant, have issues with their finances and benefits, or with personal decision-making, or both? And so that can determine whether we should try to file guardianship of person, of property, or both. So it's a very strong thing to file a guardianship against somebody, because we've had 2 physicians or 2 clinicians certify that they're incapacitated. So the effects of it can be sometimes just devastating to the people we file against. More often we're helping them because they need help in certain areas, and so they can't get it. But there's a recognition that a guardian of property is easier to get than a guardian of person. And the reason for that is because we typically lose decision-making authority over our finances first. It's a more abstract concept. I went to a very interesting lecture some years ago by a physician at the Washington Hospital Center who explained the spectrum of the loss of capacity. And first you lose the most abstract things. And the first thing I always found is that anybody that I was appointed to be guardian of property for us, that they'd stop filing their taxes, because April 15th is just another day. It comes and goes. And so they kind of start by failing to file their taxes, and they fail to file their bills. And then the spectrum kind of continues. Eventually they can lose the capacity to make their healthcare decisions. But people remember or know first whether they want to live here or there, or whether or not they want to have surgery. That capacity is lost later. So we can get a guardianship of property more easily. It has a lower burden of proof, just a preponderance of the evidence, more likely than not, 51%. And there's no jury trial available for guardian of property. The guardian of person must be proven to a higher standard and allows for a jury trial. So with a guardianship petition, we have to file certain papers. We have to file to have an attorney appointed for the person, which we'll talk about in a second. And we also have to file certain notices that would go to the persons who might be interested in it. So there's a notice that goes to the person we're filing the guardianship against, and there's a notice that is filed that we have to serve on all the interested persons, family members, and financial institutions that might be paying benefits, so that they understand what the guardianship is. It's written in lay terms, and there's a statutory or a form set forth in Maryland rules. We also have to pay a filing fee, which varies from county to county. Generally runs about $170. You know more about this than I. But
yeah, certain counties are $185, others are $165. It really is each county. It's different for every county.
Yeah, 150 to 200 range is the filing fee.
Yeah.
And again, they won't do anything until they get paid their filing fee.
They won't do anything until they get their money.
So the first thing that happens after we file a guardianship petition, and well, the first thing that happens, the court clerk looks at it to make sure all the nitpicky stuff is accurate.
All the certificate boxes are checked, all the attachments are included.
Right, and there at least one certificate was dated within, based on examination within 21 days of our filing.
Correct.
So once you get past that threshold and they get their filing fee paid, once you get past that, then the next thing the court does is an appointed attorney to represent the alleged disabled party. And that is because we're depriving them of their rights, an attorney needs to be appointed to look out for their services. If the patient already has an attorney, typically the court will appoint that person. So I have a guardianship right now where she's got an attorney who handled her stuff, and so that attorney went into court and said, hey, I've been representing Mrs. So-and-so for X many years, and so the court appointed that attorney to represent her in the guardianship proceeding. Mm-hmm. But if they don't, there's a list of attorneys that the court will call upon to serve in this capacity. And
we've even recommended some attorneys, depending on the county. You certainly don't want to ask someone that you've worked with in the past from Cecil County to go all the way down to St. Mary's County, but we have on occasion recommended that the court appoint a certain person who we know will look out for the best interest of the alleged disabled person and who is nice to work with and just generally makes the experience all around easier.
And understands guardianship.
Exactly.
It's exactly. Not other litigation.
No, it's different. It's much different than just a typical litigation suing to get a bill paid.
Right. And in that regard, I think it's important to understand the role of the attorney for the person, because they are dealing with an incapacitated client, presumably incapacitated. enough incapacitated that we were able to get 2 certificates of lacking capacity. And so they sometimes have special challenges dealing with their clients. I've been in that role as well, and that can be challenging to try to figure out what the person would want. But the important thing to understand is that attorney's job is to be a zealous advocate for their client, not to give their own report. I've seen some attorneys that go in and say, well, my client's clearly incapacitated, and I've seen attorneys sanctioned for making statements like that. So it's their job, and sometimes they're kind of a pain. I've got one where the attorney's being a little bit of a pain because their client doesn't want a guardianship, and so it's their job to assert that position to the court. So, you want to take those?
Sure. Next, Sigrid touched on this a little bit before. All of the interested persons in the case have to be served with a copy of the petition, a copy of the physician's certificates, and there are a variety of ancillary documents. One is even called Notice to Interested Persons, and those interested persons include the immediate family members, spouse, children, or if there are no spouses or children, siblings. If there are no immediate family members, it does on occasion branch off to aunts, uncles, nieces, nephews, cousins, but that's rare. And it also includes the Social Security Administration and the health department for the various counties, or the Department on Aging, depending on the person's age. It might be social services, it might be the Department of Aging. Each county has a different name for each of those various divisions, and it's an independent party who sometimes gets very involved in the case, and sometimes it's just simply placed on notice that somebody is seeking a guardianship for a resident or a member of their county. I can tell you from personal experience right now, we have a guardianship filed for a 90-year-old woman. Her sons are simply seeking to have one of them appointed as a guardian because the person who had power of attorney recently passed away. And we filed for guardianship, everybody has consented, and the Department on Aging for St. Mary's County actually filed a response and has inserted himself into the case, not in an adversarial way, but just simply to say, okay, I'm not objecting, I just don't have any information to either admit or deny that this person may or may not need a guardian. So that party is considered an interested person, and we have to serve them with copies of everything that we file. There's something called an advice of rights that goes to the alleged disabled person. It's directed at that person to indicate that if someone is appointed as a guardian, some of their rights may be taken away, or all of their rights regarding financial decision if it's a guardian of property, all of their rights with regard to their personal decisions if it's a guardian of person, or both, depending on what's been filed. And all of the interested persons do need to be given copies and served in the same manner in which you would be serving somebody in a litigation. So it either has to be by personal service through a private process server, or by certified mail with that restriction on the delivery. It has to go to that person. If somebody is serving me by certified mail at my house, my husband can't sign that little green card that we get. It has to be signed by me. So generally speaking, when you have guardianship proceedings that are not adversarial, most of the interested persons are on board with the guardianship. We can simply serve them by email as long as they respond saying that that is acceptable, and the court has then accepted that service as being okay because everybody has consented or is okay with that means of service. You do run in on occasion. We had a guardianship proceeding filed by a hospital that we represented, and the interested persons included daughters of the alleged disabled, and apparently the alleged disabled was not a good parent, and they wanted absolutely nothing to do with this alleged disabled person and refused to give their address, refused to give their email. I think we had one phone number for one of the daughters, and it became a service issue because not only was the petition somewhat incomplete because we couldn't identify, we had the names, we couldn't identify the addresses or even phone numbers or email.
The name, as I recall.
I'm sorry?
It had a common name.
Oh, it was a very common name, so we couldn't even perform any kind of search. It was practically a Jane Smith kind of name, very common. And if we did a search, hundreds of thousands of results would have come up. And we eventually got them to understand that they don't need to do anything. They just simply needed to accept a copy of the paperwork we had filed so that they are on notice. And we knew that they knew about it. We talked about it. We told them what we were doing, and they said, fine, we just don't want anything to do with it. But without being able to actually physically serve them, we couldn't proceed at either a show cause hearing or any other proceeding within the court. They weren't going to schedule anything for us until we got everybody involved.
Because the judge is always concerned that the family needs to know what's going on.
Correct. They want to make sure that the black sheep brother, for example, is not, and sorry to the guys out there for that.
Yeah.
Black sheep
sister.
Black sheep sister this time. They want to make sure that it's not the black sheep sister trying to obtain a guardianship over mom who has tons of money, and once you have that power, you then have authority and the ability to go in and clear out mom's bank accounts, give mom's $1 million mansion to you, and they want to make sure that the good siblings are aware of that. So go ahead.
Okay.
So let me go. I'll keep going. So the next thing is a guardianship itself can take roughly on average 60 to 90 days. Once you file, lately with the online filing, the show cause orders are the documents that give you the deadlines for service on all of the interested parties, service on the newly appointed attorney, and it tells you the date and time in most counties of the show cause hearing. Every now and then there's a county that won't schedule your show cause hearing until you've served everybody and you have to notify the court and then they'll schedule it. But at the show cause hearing, you as the petitioner have the burden to go in and show cause, give a reason as to why you believe this alleged disabled person needs a guardian. And that can be scheduled anywhere from, like Sigrid said, 60 to 90 days out. Sometimes it's as quick as 30 days out, and sometimes, I think we filed something in February this past year, and our hearing was in September. So every now and then you have a court that takes quite a bit of time, PG County, but most courts do it within a reasonable time. If it's contested and you get to the show cause hearing and the court does not find, based on the evidence that's been presented so far, meaning basically just the physician's certificates, that the person does need a guardian, or if it is heavily contested by either the alleged disabled person or another interested party, then the court will set in a trial. So you will actually have a trial date. You'll have to bring in witnesses, either the doctor or the LCSWC or anybody else who has information to show that this person does or does not need a guardian on whichever side you're on. And then at that point, it could be anybody's game. If you have sufficient evidence and a physician who has been treating this patient for 15 years, you're certainly more likely than not to be able to obtain a guardianship provision. But when you put it in the hands of a court, or if you put it in the hands of a jury, you really don't know what you're going to end up getting. So,
but I think there's one important caveat that I probably should address in the outline, which is that this is for a fully adjudicated guardianship.
Correct.
We have had situations, Emily just did one a couple of weeks ago, where we have gotten guardianship in a couple of hours when there is a genuine bona fide patient need. So if, for example, and I have had this happen, we need an emergency court order to do something, the patient's objecting. I had a case some years ago where we had a situation where a young man had a brain problem. We knew that he was had some kind of an abscess in the brain stem. Surgery is highly risky. His sister thought that he had a voodoo curse put on him, so she was not going to consent to surgery. This was not usually what we consider to be acceptable medical decision making, and so we wanted to do a brainstem biopsy, which is risky. But I was told by I ended up with a number of conversations in the middle of the night with the infectious disease doctor and with the neurosurgeon, because they wanted to do this brainstem biopsy to find out if the patient was in fact HIV positive, and the brain abscess was related to that. So I was told, I'm just a lawyer, that this is risky surgery, but that they really needed to know this one bit of information, because if it was something like that, they could treat it and he could recover. And if it was something, the abscess was related to some other problem, then it could not be treated. And so I was in court that next morning at 9 o'clock, and we had a court order within a few hours. We can do it in, I think, sometimes we talk about 60 to 90 days, 30 days. People are like, oh, we need medical decision making to be made sooner. We can do them more quickly. It requires sort of, pull out all the stops because we need to get all of the ducks in a row. I usually like to have a physician on the phone to be available to the judge. I have had a couple of guardianship hearings held in the hospital rooms, the patient's bedside, because the judge wanted to give the patient an opportunity to object or to state their views. So they can be done more quickly, but you need to have a bona fide reason to make it an emergency that needs to go to the top of the court's docket. You just got one for a Jehovah's Witness baby where we got consent to do an emergency transfusion. More notice is better, but if we need to do it, it can be done quickly, but still during the regular business hours. We're stuck with that. I did once on a holiday get a judge out of the hardware store to come over and sign an emergency. It just so happened one of my partners had the judge's cell phone number, and because they were friends, and so the judge, I called his wife, and she said, I'll send him over, and he came over and signed it. But that's unusual, and it was not a contested case. That was a very clear cut. Nobody was objecting. We called an attorney to consent. It went over, called the judge from our from wherever the attorney was, and so they can be done quickly when it's necessary. So, kind of sliding along with the speed at which it has to be done. So, if there's an urgent need, we can typically get a temporary emergency guardianship.
Sorry.
Yeah. So but it can be difficult. Sometimes the statutory authority for those is not clear. There's not agreement amongst the various circuit courts and even amongst the various circuit court judges as to what procedure is to be followed in those situations. And so sometimes we end up having to argue that it's a court of equity and that it has to be done quickly. I can tell you there was one judge in Montgomery County 15 years ago, 20 years ago, who would never sign them. So I would always try to avoid that judge because the other judges did not agree that that was the situation. But the law for it is not very clear. I was on a state commission 2 years ago, and I still am regularly involved in efforts to try to get that clarified. But so far, we have no movement on that. And you still have to file like a full guardianship. It just has to be, we're asking for temporary emergency relief. And again, the person has an attorney appointed to represent them.
Correct.
So the guardianship places the alleged disabled party under the court's jurisdiction. And once a guardianship is adjudicated, we no longer call them the alleged disabled party because it's no longer alleged. The court has found that they are, in fact, disabled. And so now we call them a ward. So the ward is under the court's jurisdiction. The guardian is just an agent of the court, and the court is really the guardian. And so the court needs to have reports on the status of its wards. And so the guardian must file a report. The guardian of person has to file a report on the person's status once a year. It's a very short, it just asks where they're living, if there's any medical situation that's likely to present a challenge, how are they doing. So the guardian of person report is quite simple and only has to be filed once a year. The guardian of property report is fairly complicated and detailed. And basically the guardian of property is acting as a fiduciary and must manage every asset of the ward. And I literally have I always file my accountings, and I think the court clerks generally require it down to the penny. So I actually had a letter from a court clerk one time asking what had happened to the $2 in cash that I reported that I found in the person's dresser drawer, and I was able to point them to the fact that I had reported it under blah 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 date that I had made a deposit of $2 to track that. So the guardian of property has more work to do. It's important for the guardian of property to understand that this is a fairly hands-on, time-consuming process, particularly at the beginning. You're trying to seize their bank accounts. You're trying to get a hold of their property. You need to make sure that the property is insured. I saw a court case not too long after I started doing this where somebody had sued the guardian for failing to maintain property insurance. Property burned down. Guardian's fault for failing to maintain insurance on the property. So the guardian has a lot of duties and responsibilities and must be extremely meticulous about bookkeeping. So when we get calls from our hospital clients or our CCRC or nursing home clients, sometimes they'll say, oh, so-and-so's wife would like to be his guardian, or his next-door neighbor's willing to be his guardian. And I always insist on talking to that person to make sure that they understand what being a guardian of property in particular entails, because it's very time-consuming, and I have twice had to go to court to have a layperson removed or replaced by an attorney because of the fact that they did not keep adequate records, did not fully understand what their duties were. It's not their money. They are acting as an agent of the court. They have to use segregated bank accounts. They have to file everything in the name of the ward and in their name as the guardian. So it's a fair amount of hassle, and I think that only people who really know what they're jumping into ought to serve. One of the cases that I had to replace was we had a patient in the hospital. We'd filed for guardianship, and the person's son, who was a very fancy doctor in California, the training and appointments out the yin-yang, but not able to serve very effectively as a guardian of property for his mother, I can't remember, in Maryland, because he was doing it long distance. Accounting was not his thing, and he was just thinking that he'd be able to manage things long distance, so we had to have that guardian replaced. No insult to him as a doctor, but not a good choice for a Maryland guardian. So it's a kind of a pain in the neck, and there's some risk associated with it, and nobody always likes the decisions that are made by the guardian of property as well. So the process of gathering and inventorying the ward's assets can be very time-consuming, and it's difficult to do from a distance. So I always recommend that the person be local if we're going to have them. Guardian of person just basically has to answer the phone, and their decisions sometimes can be a little easier to get some help on. But the guardian of property really has to do a lot of running around and is, again, responsible for aspects of their financial life. And unlike the power of attorney, the guardian of property has very specific obligations, like filing their taxes. So you can't just not do certain things if you're the guardian of property.
They have to do it. And another thing we come across, this was even something most recent, when you're dealing with, when we file on behalf of the hospital, for example, and an independent attorney is appointed as a guardian of property, they may not necessarily know the ward, and they most likely don't know them at all. So they have absolutely no idea what kind of assets the person has. And oftentimes you'll find that a ward's children don't want to be the guardian of property, because they don't want the responsibility, they don't want the obligation, they don't want to have to answer to their siblings about the decisions that they make on behalf of the ward. So, you know, just like the court has a list of attorneys that they appoint to represent the ward at the hearings and the various trials, they also have that same list to represent, to appoint an attorney to represent or to act as the person's guardian. And they don't know anything about the ward. They don't have any idea how many bank accounts, investment accounts, do they have real property? Is it rented? Is it owned? Do they have mortgage payments? If they've been in the hospital for a significant period of time, what the heck is the condition? How many, violations do they have from the county for tall grass? Exactly. Where's your car? We just had a situation recently where the guardian of property was appointed some months ago, and they just this past week found the ward's car in Pennsylvania. No idea why it was there or what he was doing up there or how he ended up in Prince George's County with his car.
Was that his car?
Yeah.
It was there, no less.
Yeah, exactly. So there are a number of things and sort of roadblocks you can run into and just sort of interesting things. You literally have to go to someone's house and root through all of their things to figure out what mail they're getting, and nowadays with everything being electronic, makes it even more difficult because somebody might not get paper copies of bank statements or financial statements or bills. Everything comes electronically, and if it's not automatically deducted, that's an issue too. Or if mortgage payments, for example, are automatically deducted, when you close out that individual's account and open up a new account, you've got to make sure
guardianship account.
Exactly. You'll need to make sure you can transfer all of those automatic deductions as may be needed.
And again, because of the potential for misappropriation, the guardianship is the guardian's often bonded.
Correct.
An attorney appointed by the court is often not bonded because I fear disbarment more than I fear worrying about a bond foreclosure. Correct. Disbarment being the worst case scenario for me, but so sometimes you can waive it there, and the bond cost does come out of the ward's assets.
Mm-hmm. Yeah. So once a guardianship is fully adjudicated and fully completed, the guardian will become permanent. And that guardian stays the guardian of the person and or the property until somebody makes the determination, typically the court, that either they don't need it anymore, maybe the person has recovered, maybe the person was in a coma, for example, and has finally woken up and is able to now take care of him or herself. That would be an unusual circumstance. Usually guardianships are terminated by the death of the ward or by the replacement of a guardian. That's really the only time that a guardian would be completely removed or taken out of that position. Every now and then you have a situation where there are no assets left of the ward, so the guardian of property can complete his or her duties by filing an application for some sort of Medicaid assistance, and once that's completed,
and then you make the nursing home the rep payee.
Correct. There's really nothing else for them to do, and they can petition the court to terminate their duties as a guardian of property.
So again, at all times, the agents function, the guardians function as the agents of the court, and thus can be brought before the court to be held accountable. So if we don't like something that the guardian is doing, we can go petition a judge to have them be replaced or removed or to answer questions.
Correct, or to elaborate on something that seems odd in an account or in a report that they filed on an annual basis.
So every county in Maryland has an office, typically within the Department of Social Services by whatever name they have in that county, that can serve as the guardian of the person, but they are prohibited from handling money. So the court, again, often appoints an attorney to be the guardian of property.
Okay, we'll open it up to some questions now if you all have any questions. We do have one. Can a guardianship or power of attorney help if a resident is not paying?
Absolutely. That's one of the things that we use them for. The guardian of property is responsible for paying things. And so if you have a resident of a facility, for example, that is not paying their bills, if you believe you can sue them if they're competent. You can sue them anyway, but that doesn't necessarily do you any good if they're just not able to respond because they're incapacitated. So if they are incapacitated, you follow the guardianship process. 2 physicians, or one physician and one of the psychologists or licensed clinical social worker certifies they're incapacitated, and we follow the guardianship process, get a guardian appointed. That is a significant percentage of what Emily and I do.
Absolutely. And, if for some reason a guardianship is not necessary, if someone has a power of attorney, that can actually be used in lieu of a guardianship if you can get that attorney, in fact, to agree. Like Sigrid mentioned earlier, the powers that are given to you as an attorney, in fact, under a power of attorney document, whether that's a financial power of attorney or just a general durable or Maryland statutory form, those obligations are not obligations. They're really voluntary acts. So sometimes we can't get the person who's been appointed to make payment, or maybe they dispute it or disagree with it, or maybe the alleged disabled person, no guardianship yet, so they're not quite a ward, but maybe the alleged disabled person, or just the person that's not paying is telling them that they don't have to or that they don't want to because they don't feel that they're being treated the right way.
Well, we had one where there was high family conflict. There were 2 parents were in a CCRC, 2 brothers, a great deal of conflict amongst the family as to some issues with the patient's care, and the brother who had been given power of attorney said, I'm done dealing with this whole situation. I'm walking away. And so we had to file a guardianship in that case to have somebody independent appointed to manage their finances.
Right, and I think in that particular situation, there were sufficient finances to continue to pay for them, but the 2 sons, one didn't want anything more to do with it, and the other son, the parents didn't really want him to be in charge of their finances.
He had a history of being a little impecunious, so it's better to have somebody independent appointed.
It's kind of sticky, but we got through it, and the guardianship in that case was very helpful.
And the good news is most of them are not contested. Most of the time it's a vehicle to get the person some help. And I would say of the ones that I've done with you in the last 2.5 years, I think we've had 1 or 2 contested, and we filed probably 75.
Right.
Something like that.
Yeah.
So just my off the top of my head number. But so most of the time they are pretty straightforward.
Right. Most of the time we do fall in that 60 to 90 day window of getting a guardian appointed, having it become permanent without going through a full-blown trial. I don't even recall the last time I had to go through a full-blown trial.
Well, the one you stuck me with.
Oh, this one. Just one. My evil plan.
We do have an additional question that came in regards to power of attorney. When reviewing a person's power of attorney, is it acceptable for the notary to also be used as a witness on the document?
Yes. Yes. Typically, the notary is a witness, so it's just another type of witness.
So long as that notary is not also the person being identified as the attorney in fact.
Yeah, the agent appointed under the document cannot witness them.
Correct.
Too much self-dealing.
The notary can do both.
All right. Thanks, everyone, for your questions. On behalf of Sigrid, Emily, Whiteford, Taylor, and Preston, and Leading Age, thank you for joining us on today's webinar. You'll receive a follow-up email within 48 hours with a link to view the recording. Have a great day.